Is interference with child custody family violence? Let's talk about it in this video. Interference with child custody, Texas Penal Code, Chapter 25.03 is found in Title 6 of the Texas Penal Code. Remember that. It's fixing to tie in to the rest of this video. Title 6, Chapter 25 of the Penal Code. What is interference with child custody? Interference with child custody is, in layman's terms, everyday people terms, is when your baby mama or your baby daddy don't want to turn over your child for possession and access, visitation, with a court order. So when you have a court order and your ex doesn't want to let your child go with his mom or with his dad during their periods of possession, that's interference with child custody. Legally, what the law says is when the persons know that the person's taking and retention is in violation of a court order or judgment, including temporary order. That's what interference with child custody is. Basically, your baby mama or your baby daddy don't want to turn over the child. That's it, right? You have a court order, you show up, judge says I could have little Johnny here, and your baby mama is being spiteful, your baby daddy is being spiteful, whatever it is, that's what interference with child custody is. It's a state jail felony here in the state of Texas. Most law enforcement agencies and officers, sheriff's deputies, constables, they'll all tell you it's a civil matter. In fact, they'll kick you from agency to agency, tell you to go talk to the constables because they enforce that law. They'll tell you whatever they have to tell you. They'll lie to you in order for you to leave them alone. They don't want to get involved with these issues. Here's the thing. Interference with child custody, Texas Penal Code 2503, it's a state jail felony. It's criminal. That's what law enforcement's job is, to enforce the criminal law. Interference with possessory rights, Chapter 42.002 of the Texas Family Code, is a tort, and that's handled in a civil court. You can hold somebody in contempt or file for an enforcement by contempt in a civil family court for interference with child custody, breaking the court order. So the question was, is interference with child custody, Texas Penal Code 2503, considered family violence? Let's check it out. So as I was saying, interference with child custody is in Title 6 of the Penal Code. Title 6, offenses against the family. If you go to Chapter 81 in the Family Code, under Title 4, it says protective orders and family violence. Scroll down to 81.0015. It's at the very top. It says, for the purposes of this subtitle, there is a presumption that family violence has occurred if. Okay, let me read that again. For purposes of this subtitle, there's a presumption that family violence has occurred if. And if you go down to number 1, right after that, the respondent has been convicted of or placed on deferred adjudication, community supervision for any of the following offenses against the child for whom the petition is filed. Let me read that again. The respondent has been convicted of interference with child custody. Oh, we haven't gotten there yet. The respondent has been convicted or placed on deferred adjudication for interference with child custody. We're not there yet. Community supervision for any of the following offenses against the child for whom the petition is filed. An offense under Title 6 of the Penal Code. An offense under Title 6 of the Penal Code. Title 6 of the Penal Code, Chapter 25.03, offenses against the family. So bigamy is 25.01. We scroll down to 25.03. So we scroll down to interference with child custody. A person commits an offense if the person takes or retains a child younger than 18 years of age when the person knows that the person's taking or retention violates the express terms of a judgment or order, including temporary order of a court disposing of the child's custody. An offense under this section is a state jail felony. Now let's talk about it. So if we go back to the Family Code, it says Chapter 81.0015, we went over this presumption. For purposes of the subtitle, there is a presumption that family violence has occurred. Let's figure out what the legal definition of presumption means. In legal terms, a presumption is an assumption the law makes about a fact or set of facts, which is treated as true unless proven otherwise. Presumptions are used to guide judicial decisions, often shifting the burden of proof to one party. And if you look down to number 1, the respondent has been convicted or placed on deferred adjudication, community supervision, probation, for any of the following offenses against the child for whom the petition is filed. Let me read that again. I reiterate things and I read things 2 or 3 times so they actually try to set and resonate with you as I'm reading it. The respondent has been convicted or placed on deferred adjudication. Okay, that's where the issue lays. If you show up to your ex's house trying to obtain your children and law enforcement does not want to give you a criminal complaint for interference with child custody, how do you obtain this presumption? You can't obtain this presumption if there's no record, if law enforcement isn't enforcing the penal code. So therefore, you can't get a conviction or deferred adjudication, right? Right now, family violence is hot. We see law enforcement, we see DAs, we see judges, we see family court judges, magistrate judges, all are issuing out protective orders for the safety of certain individuals. And I'm here to tell you that interference with child custody is family violence because there's a presumption that family violence has occurred. But again, when you go to make those criminal complaints for interference with child custody, law enforcement won't give them to you. So you can't get a conviction or a deferred adjudication probation. The reason I'm making this video is because I tried to highlight these little loopholes for you guys. While the family courts, protective order courts, magistrates, DAs are all pushing for these protective orders based on family violence, I think if your children are being denied from you with a court order, that's also family violence. And it says there's a presumption in the family code itself. Now, remember, family violence, domestic violence, protective orders, a lot of those cross between the family code, the Code of Criminal Procedure, and the Penal Code. So a family court judge has to know that the Code of Criminal Procedure and the Penal Code in order to enforce a protective order properly. And sometimes I feel that that's why they don't enforce interference with child custody and they tell you to go back and file a contempt action for violating the court order. In Texas, 94% of non-custodial parents are fathers. If fathers were obtaining protective orders based on family violence for interference with child custody, that would totally crush the system. It is what it is. I'm not an attorney. I'm not a lawyer. I didn't go to law school. I know how to read. I found these loopholes. You use them how you want. But I think if somebody is denying you your children based on false allegations of abuse and they utilize a protective order to deny you, I think parents that are being denied possession and access due to false allegations should absolutely use all aspects of the law. And right now, if law enforcement and DAs aren't allowing you to bring those criminal complaints for interference with child custody and you're unable to get a presumption, I think you should chase down the protective order route and start demanding that you get orders of protection when the other parent is denying you possession and access. I hope this video was informative enough for you. Again, I'm not an attorney. I didn't go to law school, putting 2 and 2 together. I'm just trying to help parents reunite with their children based on a judicial court order. If you have any more questions, if you have any comments, please leave them in the comment section below and we'll check you out later.